Hi, I'm Kellen Bryant, Florida Bar Board certified elder law attorney who has been involved in creating at least 1,849 estate plans for clients over the last 15 years. In this 5-minute video, I'll break down the most important 7 legal documents every elderly adult should have to protect their assets and their wishes. Let's go. First, there's the durable power of attorney. That is a document that you're going to sign naming an agent. That is the person who will manage all financial affairs in your name, not your trust's name, when you are no longer able. It works immediately once you sign it and once the agent has that document. The durable power of attorney is very important in order to avoid guardianship if you become incapacitated. Most people will say, I'm not going to sign one, but I'll sign one when I need one. But the problem is when you need one, you cannot sign one. You will be incapacitated and potentially unable to know how to write your name. And therefore, to protect your affairs, a $15,000 court guardianship will be required. That durable power of attorney stops working when you pass away, and it is a very detail-oriented and intense job. Make sure that document is worded properly for long-term care planning. Next is the designation of healthcare surrogate. That is a document that you're going to sign to appoint somebody to make medical decisions for you and to consent to medical treatment for you if you are mentally incapacitated. That document in Florida, once signed, will only work once your chart is identified as medically incapacitated. Then the medical teams will be conducting their questions and inquiry and consent with the person you name as surrogate. Third, we have a living will, also known as advance directives. The living will is a document that your person that you named healthcare surrogate will review to make medical decisions. A living will says whether or not you would like to be kept on life support if you are in a persistent vegetative state, end stage, or terminal condition. That's the basic living will in Florida. You can find the templates online in Florida statutes. And the living will is not a DNR. A DNR is something that your health surrogate can sign with your doctor. Attorneys do not prepare a DNR. The fourth document is a HIPAA authorization. Your medical information is protected, and your medical information can only be in the possession of you and your medical providers. HIPAA is a headache to deal with as a caregiver and for yourself. And in order to manage your medical information, we recommend a general HIPAA release. Every one you've already signed is usually specific as to that provider. We recommend a general blanket HIPAA release. Fifth document is a designation of pre-need guardian. This is a document that is used to protect your wishes in case exploitation by other people. Now, what if somebody, while you are no longer in your right state of mind, has you sign new document? The right people who you want to take care of you will want to protect you. And if somebody's looking to exploit you with those new legal documents, their only right of recourse is in a guardianship proceeding. And that designation of pre-need guardian will protect your root wishes if you were ever a victim of exploitation. Document number 6 is a last will and testament. The last will and testament only works when you pass away and have an asset just under your name. Last will and testament is important to name your final wishes, such as cremation, burial, and what to do with your remains. It's also important to name who's settling your affairs as your personal representative. If you don't have a trust, everything that you want to have happen to your estate will be covered in the will, and it only covers assets that are in your individual name when you pass away. The last document for your estate planning is the revocable living trust. It is used to avoid probate, and it is usually in replace of your wishes stated in your will. And the great thing about a revocable living trust is it addresses contingencies better than a will and coordinates your estate and your affairs better than a will. Do you want to learn more? Check out my next video on the estate planning 101 and the things you should be thinking about.